As part of your proxy statement filed with the SEC, you will disclose certain information about your board's nominating committee processes, including any required director nominee qualifications. Today on Zippy Point. I'm Brown-Forman and I'm a big fan of yous. Before I bring on my guest to explain in more detail about this disclosure, let's run down some of the basics, the legal requirements. Item 7C of Schedule 14A refers to Item 407C1 and 2 of Regulation SK, so that's in the proxy statement. And then Item 10, Part 3 of Form 10K refers to Item 407C3, so that disclosure is going in the 10K, and then there's also a 10Q analog. We'll talk about that in a moment. The purpose of this disclosure in Item 407C elicits disclosure to help shareholders evaluate a nominating committee and understand how it works. This disclosure has a distinct relationship with Item 401E1 of Regulation SK, which requires directors' qualifications and skills disclosures. So in combination with these two types of disclosures, shareholders will be able to compare and evaluate the qualifications and skills of directors and director nominees based on the standards established by the board. Note that I have two separate Vid-Guides. There's one about director biodisclosure, and then there's one about disclosure of director qualifications and skills. Links to those videos are beneath this video. So what to disclose? Item 407C25 requires a description of any specific minimum qualifications for director nominees recommended by the nominating committee. That includes the quality or skills that the nominating committee believes that all their directors should possess. So those high-level things like integrity, time availability, high standing and reputation, achievement in one's field, you get it. And then there's any specific qualities or skills for one or more of the directors to possess, such as independence, industry experience, financial or accounting expertise, global experience, whatever each particular board specifically seeks. Item 407C26 requires a description of the nominating committee's process for identifying and evaluating their director nominees, including nominees recommended by shareholders and differences in how shareholder recommended nominees are evaluated compared to other nominees. 407C7, this requirement is sometimes forgotten. Companies are required to identify the source of each nominee recommendation, whether it be the CEO, some other executive officer, a board chair, another independent director, maybe used a director recruiter search firm, whatever the source might be. It might be part of a financing where the arrangement results in the lender getting a board seat. And if the company pays a fee to a recruiter, to a third party, to identify or evaluate nominees, 407C8 requires disclosure of the function performed by the third party. Description of the shareholder nomination policy. 407C2 requires a description of the material elements of the nominating committee's policy for consideration of any shareholder nominated candidates, including a statement as to whether the committee will consider such candidates. Under 407C24, the procedures for shareholders to follow. So shareholders, good luck with that. Note that the CorpFin staff takes a broad view of what constitutes a policy here. For example, there's no requirement that this policy be in writing. Now, if you materially change the procedures for shareholders to follow, under item 407C3, you must disclose those new procedures if they're materially changed in the Form 10Q or the 10K for the related time period in which those changes were made. Diversity policies, item 407C26 requires disclosure of whether, and if so, how the nominating committee considers diversity in identifying director nominees. So the SEC is not actually defining the meaning of diversity, leaving it up to companies to define it based on their own perspectives. Originally, most companies elected to use a pretty broad definition of diversity, but given the heightened attention to this topic in mainstream society, we may see boards revisiting their policies right now or in the near future. Again, the CorpFin staff takes a broad view of what constitutes a policy, and the staff goes even so far as to that the mere disclosure of the fact that diversity is one factor that the board considers in identifying director nominees is a policy in their view. So if there's a policy in place, both item 407C2 and this CorpFin staff interpretation requires companies to describe how their diversity policy is implemented, as well as how the nominating committee assesses the effectiveness of its policy. The location of this disclosure, there's no mandated place for it. In some instances, the disclosures are made in a standalone corporate governance section of the proxy. In some cases, the disclosures are made as part of or adjacent to the director's qualifications and skills disclosures or near the director bios. And all that might be in the election of directors section. Note that the stock exchanges have listing standards governing the nominating committee's process as well. So if you're with a listed company, you're going to check the NYSE or the NASDAQ rule. Let's look at some examples. Here's cognizance, really nice board composition and refreshment. These disclosures are typically pretty long, take a few pages. So here you have this covers waterfront. Here's Alphabet's disclosure, again pretty lengthy. Coca-Cola's disclosure, always nicely done. And the Southern Company. You notice that I keep going to the same companies for examples, but they got the best disclosures. Our guests today are Leah Huddleston and Candace Jackson. Leah is Vice President, Associate General Counsel, and Assistant Secretary at Brown-Forman in Louisville. She's been in-house at 3 public companies. Candace is at Mayer Brown Rowe in Chicago. She's been in-house at 2 public companies. They both went to the University of Michigan, as did I. I'm Brock Romanek. Today on Zippy Point.
Quick Zips by Zippy Point.
Quick and dirty. So Candace, the nominating committee process disclosure, how do you like to see this type of disclosure formatted?
I will say that I don't always see a lot of creativity go into formatting this disclosure. A lot of companies kind of pull the paragraph out of their charter and put it into the disclosure. And so I see that a lot. I think it does go a long way to try to kind of rephrase or summarize that disclosure and make it a little bit more digestible for shareholders, because the charter language is quite formal. So I do think that, with the SEC's, directive to use plain English and just for readability for investors, it does make sense to kind of, synthesize that information into something a little bit more digestible, maybe bullet points or just a more streamlined narrative disclosure.
I agree with you, Candace. This is a tough place to be terribly creative, and the filing. I've seen companies use bullet point. I think that's probably what you see in addition to the paragraph disclosure. But yeah, don't see a lot of creativity here. I'm sure someone can think of a nice way to come up with a pie chart or something in terms of qualifications or some sort of visual, but I have yet to do that.
And Leah, where do you like to place this disclosure within the proxy?
Yeah, so typically you'll see companies have a corporate governance section where they'll talk about the structure of the board and the committees and the board's role in risk oversight. But that's typically the place where I see it, because it's all things governance related under one section. And I believe you typically see this before the nominees are listed in the proxy statement.
Yeah, I'd say I see it usually in a couple of places. Often it comes as a part of the description of the roles and responsibilities of the nominating committee, but I also see it quite often as kind of a standalone at the beginning of the section of the proxy that talks about the election of directors. So often their companies will drop in, here's how we evaluate candidates. Here's, how shareholders can submit their nominees and how we evaluate those nominees. So you do see it kind of come in 2 different places, but I think those are the most common.
And Candace, what are the pros and cons of placing this nominating committee's charter on the company's IR webpage rather than?
Yeah, well, the committee's charter, if you're a New York Stock Exchange company, is required to be posted on the company's website. I do think that, one thing that a lot of companies have started to realize is that they really need to be very strategic and specific about what is in the charter, what the roles and responsibilities and what the process and procedures are that appear in the charter, because once it's public, it's on the website. If they're not doing that, if they're not, carrying out those responsibilities, or if they're not following that process, then, there could raise, it can raise some liability issues about whether or not they are carrying out the functions as required by the company's governing documents. So I would say that's the con, right? The pro, I'm not sure if they're really pros. I mean, it's often required to do. And so, I guess that's a pro, I don't know, but yeah, on the con side, you do just want to really be careful about not using just kind of a standard template nominating and governance committee charter if that's not what the committee is actually doing. You really want to be specific and tailor it to the committee's practices and what they're actually doing.
I think a pro of putting it on the IR side is that it's accessible to shareholders and it's transparent. And so if anybody has questions about what the roles and responsibilities of the committees are, like, you can go on the website and find it. I selfishly like it because I go out and benchmark from time to time, and you want to see how other people are thinking about their charters, but it's shareholder friendly to provide this information, and versus like going to a proxy statement and trying to understand what the committee does there.
Yeah, great points. Yeah, great points.
And Leah, how involved is the nominating committee in reviewing the disclosure about its processes?
Yeah, so the nominating committee is very involved. Typically each year, shortly after year end, as internal counsel or corporate secretary's office will take a crack at drafting this disclosure, and the committee is responsible for reviewing that in due course prior to either the filing of the 10K or the proxy statement. So they're pretty involved in the companies that I've worked with.
Yeah, I would say, the companies that I've worked with, they all send their proxy statement to the full board to review. Sometimes they will send specific sections to specific committees to take a look at, and I don't often see companies, pull this disclosure out specifically for the Nom and Gov committee to focus on, but there is an expectation that when the Nom and Gov committee members are reviewing the proxy, that this is an area that they're going to particularly focus on and provide any comments that they have. So, I would say most companies, the committee is quite involved.
So Leah, can you speak to the interplay of the SEC's disclosure requirements regarding the board's nomination process and then the stock exchange's listing standards?
Yeah, so the New York Stock Exchange has listing requirements, and they require companies to have a nominating committee charter that address a number of items. In addition, the New York Stock Exchange rules require companies to have corporate governance guidelines that articulate director qualification standards, things like can you sit on multiple boards of directors, how long can you sit on the boards, etc. Moving over to the SEC's rules, item 407 of Regulation SK requires a company to state whether it has a nominating committee, the process that a shareholder goes through to submit a candidate for election to the board, as well as qualifications that the candidate is supposed to meet. And so there's the interplay in terms of the requirement as well as the actual disclosure. So kind of the criteria is set up in the charter as required by the New York Stock Exchange rules for NYSE listed companies, but then you're required from an SEC perspective to provide disclosure surrounding those requirements.
So Candace and Leah, we did not cross paths at the University of Michigan because I'm a little bit older, but I wish we had. I have fond memories. What little memories I have left, it has changed. But I'm looking forward to one day being able to get back onto campus and having a walk around Ann Arbor, such a beautiful town.
It
It
is.
is.
Thank you very much.
Thank you.
Thank you, and go blue.
Go blue.